Hi everyone, I'm here with Andrew today, and we're going to be discussing mediations. What it is, what to look out for, how to prepare yourself, how your lawyer should be preparing you, and different strategies that are used both by your lawyer and the other side, so you have an idea what you're walking into.
Pretty much any injury claim, if it's in litigation, at some point will have a mediation. Now, depending on the jurisdiction you're in, some jurisdictions require mediation. That means you must have a mediation before you can go to trial. But even in jurisdictions where it's not mandatory, it has become the norm. I think to start, we should explain to people what a mediation is.
Yes, so mediation is a part of what we call an ADR, alternative dispute resolution. And it is, like you were saying, the most common tool that we use. And it's a place where you have a non-partial third party that will mediate. You will have your own lawyer and you will have the opposing side as well come to the table. They're going to have an amount in their heads about what they believe the file is worth. And essentially, it's negotiation. We go back and forth discussing our first offer, second offer. And the job of the mediator, if they're good, is to essentially tell the other side why their file or their case is bad, and do the same thing for us. And as lawyers, what's important for us is to determine what part is an exaggeration and what part we can take away for our file, thinking, you know what, that is a hole that we can address further down the line. So even though mediation, a lot of people think is just a place for settlement, it's also a place where we understand our file through the eyes of the adjuster, the eyes of the insurance company. And that's really valuable input that you will not be able to have in a different setting.
For prospective clients that might be facing a mediation, wondering what their role is and what it's going to look like, I generally explain to clients, mediation, you're going to attend with your lawyer. Okay, so if you're a plaintiff, you're the injured party or the family of an injured party, you and your lawyer will attend. And the good news is you're not going to be examined. You're not going to be asked questions. You're not going to be forced to undergo any medical assessment. Really, you don't have to say much to the other side. You'll have the opportunity throughout the day to speak to your lawyer, but there won't be that sort of pressure of like similar to a deposition or something like that. On the other side of the case, the defense lawyer, typically a representative of the insurance company, an insurance adjuster, will attend. In the context of personal injury cases where there is insurance on the opposite side of the case, it's extremely rare that the actual defendant or the at-fault party attends. Is usually just the insurance company and the insurance company's lawyer on the other side. The mediator, as Teresa mentioned, is the impartial middleman or middle person that tries to facilitate the dialogue or the discussion between the two parties to try to get them to come to a consensus on value. And if they can reach an agreement on the value of the case will settle. The reason why we use mediators as opposed to just sitting around a boardroom table is because negotiations get heated. Both sides are invested, have a strong view typically of their case, believe in it. If you negotiate with that kind of emotion, sometimes it forces people to stand up and walk away, get offended, argue, which really doesn't facilitate getting to the objective. The good news is, apart from brief opening introductions where each side gets to present their theory of the case, the majority of the mediation, the lawyer and their clients are alone. So if Teresa and I are mediating on behalf of one of our clients or attending mediation with one of our clients, it'll be the two of us and our client in a conference room. Or if our client's unable to attend in person, by Zoom. And it's just us. And we can get emotional, our client can get emotional, we could get angry, we could say whatever we want, and no one in the other room is going to hear it. And in fact, we'll bring the mediator in, and we'll tell the mediator, they're wrong, they missed this, they missed that, they don't know the facts of the case, they haven't read the medical records, they must have not looked at the police report or the witness statements, and explain our point of view. But the good news is, no matter how heated we become with the mediator, a good mediator will walk out that door, exit our room, walk down to the defense room, and very politely and comfortably be able to articulate those points without any of the emotion attached and say, well, have you considered this? And sometimes the mediator may not even say it came from the other room. The mediator could say, I read the records. Have you considered this, or have you considered that point of view? And so that's the whole idea, is that you keep the parties there. The mediator will go back and forth between the two rooms, or if there are more parties between the various rooms, we may make a demand for a certain amount of money, and then the defense responds and the mediator will walk in and tell us what it is.
We also provide the mediator with a brief, so they will have all the information. Both our side and the defendants will go ahead and basically outline the strengths of their case, and the mediator is actually able to, read both and determine on their own. Generally, the mediators are lawyers themselves or lawyers who have since retired practicing and just do a mediation practice. So they know exactly what to look for. They know when a file is strong. They know when a lawyer is lying or perhaps may not know the law. And they're able to level set the playing field more than we could because, like you said, people can get very emotional. It's easy to see the opponent as the enemy, whereas a third non-partial party will not see it that way and more of, okay, let's get this done. Let's get this file settled and let's come to a resolution that's beneficial for both parties.
Yeah, and you mentioned something actually important, which is the documents or the mediation brief or memos that get served in advance of the mediation. So how important are those documents to the ultimate success or outcome of the mediation, do you think?
It's, I think, one of the most important things. You can have a great mediator and you can have great lawyers on both sides, but if you don't have a brief that details the strength of your case or even what the case is about, there's really nothing to negotiate. During a mediation, you have a opening, which, both lawyers will do. It's a very short synopsis of what your file is, what happened in the accident, etc. However, it's just not going to be enough. The brief is an opportunity where we bring to the table. Our firm is very detailed in our briefs. We talk about every single doctor's notes and diagnosis, and we really show that we know our stuff. So it's an opportunity not only to show the mediator what happened in our file or what is going on in our file, it's also an opportunity for us to show the defendants, hey, we know our stuff, we know what this file is worth, and we're ready and willing to put up a fight if it goes that way and if the file does not settle.
Yeah, good point. Now, both you and I also have the experience of being on the defense side in our past practice, you more recently than me. Share a little bit about how that information is used by the defense and why it's important to really prepare good materials in advance of the mediation and how that's used in the defense camp with the insurance company, with the defense attorney to help put them in a position to bring enough money essentially to get the case settled.
So it's actually quite an art, I would say, mediation briefs. And this is why I say that. As a, insurance defense lawyer, if I got a mediation brief that was 600 pages, I would think this person doesn't know anything about the file. This is lazy, it's sloppy, and I'm going to just walk all over you, essentially speaking. Yeah, I'll read the actual substantive part and I'll say, don't worry about this one. Because if you know your file, you would be able to hand select the very important, strong matters, the medical records that are important, the reports that are actually meaningful, and you wouldn't try to bombard me with all this information. Also, keep in mind, that looks really bad for the mediator, because even though they're supposed to be non-partial, if you give me 600 pages to read, 2 days before the mediation, I'm going to be a little bit disappointed in your conduct and also disappointed in your work ethic because it is sloppy and it's lazy. The other side is if, I get a mediation brief and it's 2 pages, I'm thinking the same thing. Why would I come to the table or why would I get my client to bring more money than necessary when I know you don't know the file? It's really easy to give a bad impression of yourself even before the mediation actually starts. From my end, if I saw a well put together mediation brief, which, for example, would be detailing again, the different conditions, the symptoms, what has happened in their lives since, how this accident has impacted them, and also specifically the codes of the diagnoses, the symptoms, then I feel, okay, they know what they're doing. And I'm going to tell my adjuster, listen, we need to come to the table because trial may be actually risky for us. So then we're able to bring a little bit more to the table to make sure that we're able to settle, as opposed to drag this on if I know that your case is soft or you don't know the case.
So it shows preparedness. It shows the level of basically preparedness and the work product of that lawyer, which gives you some insight into how they will be as a trial attorney as well.
It actually speaks volumes to the firm. A lot of lawyers don't understand that your reputation as a lawyer follows the firm as well. So if I was working with a lawyer, a personal injury lawyer, and they were always settling and always taking the lowball offers, I'm going to think, well, in the future when I have you, I'm only going to give you lowball offers and even lower than I've given you. And also, I'm going to assume your firm is also training their employees to do the same. Now, for the rest of the files that you have with me, I'm going to lowball you more and more and more. So it's very important that you don't establish that kind of reputation, because it will follow you. And not only that, it will follow the law firm.
Yeah, that's a good point. One of the things that I like to tell clients is the whole mediation, in my view, is really built for insurance companies. It's built to save insurance companies money. It's built to close files at less expense to them, really to let them get away with paying less. That's just my perception. I don't know if that's a fact, but that's my perception. And I see mediators use phrases like success attached to settling and failure, or the mediation has failed, where the case is not closed at the end of the mediation. When I'm preparing a client to attend mediation, the first thing I want to tell them is the mediation is not the negotiation. It's not like, hey, we're going there to write a test and we're either going to fail if we don't settle or pass or succeed if we settle. It's not the negotiation. It's simply a part of the negotiation. The negotiation is the entirety of the case. You're negotiating all the way up until you walk into that courtroom and you start trial. That's always the mindset I'd like my clients to be in. We're not going there to settle. We're not going there to chase a settlement. We're going there to present your case in the light that we believe is fair, reasonable. The numbers we ask for, meaning the amount of money we ask the insurance company to pay you, is going to be supported by facts, by evidence, by rationale. We're going to present that to the mediator. Then we're going to listen. We're going to listen to what they come back with. We're going to listen to the message. We're going to try to use it as an opportunity to find out why they're only offering what they're offering if it's not what we're asking for. Why? What's the rationale? Where's the weakness? It's an excellent opportunity to hear what they think is wrong with your case. And I love the fact that defense lawyers like to talk, because it gives me an opportunity to learn. Okay, that's what you think is wrong with my case? That's not so bad. Most of the time, it's not so bad. And I leave there feeling more confident about the case because I know what's still left to develop and where I can get the information or the evidence to reinforce those, what I'll call perceived weaknesses. Okay, they think we're weak on that part of the case. It's really important to me that the client goes into the mediation with the mindset of, it may settle. If it settles, fine. At the end of the day, at the end of the process, we will know the most amount of money that insurance company is willing to pay on that particular day, period. Doesn't mean that's all your case is worth. It means that's how much money they're willing to pay on that particular day. And if it's enough, if it makes sense, they'll settle their case. And if it doesn't, then we don't settle the case.
You know, the idea of walking away may sound scary to a lot of clients. I'm sure they're tired, and, you know, a lot of clients come to us and say, hey, I just want this over and done with. But I think the best way to walk into mediation as a lawyer, and you should be confident in that, if your lawyer is willing to walk away, it's a really good sign, because that means they're prepared and they're willing to fight with you, for you. And also, it's a great opportunity, like you were saying in a mediation, to see where the holes are. I agree with you. It's not really about negotiations. It's about understanding your file even better from the eyes of the adjuster, and also what we can do then as your lawyer to strengthen your file. Also, it's a really interesting thing you say that mediations are technically tailored for the insurance companies. It really is. And I feel there are times where insurance companies will purposely schedule a mediation early to catch you off guard, to exhaust you, to beat you down. And that's why it's important to have a lawyer that's willing to put their foot down and say, no, we're actually going to walk away if you're not willing to come on a good faith basis. And we have no fear in that, because the real damage is done when you take a settlement and it's not what the file is worth. Your client deserves the full amount, and your fear of trial and your fear of what the mediator will call failure in walking away from mediation should not stop you from advocating for your client fully. Oftentimes, it's an opportunity for us to, nail the medicals, nail the liability after the fact. So we're walking away actually with more value than the settlement itself. Now we have tools to help you get the settlement that you actually deserve.
Yeah, that's good. And you said something, a good point, I think. Also, for clients out there, they could feel somewhat defeated if their case doesn't settle at mediation. But if your lawyer is willing to walk away, that should give you confidence, because that means your lawyer continues to believe in your case, continues to believe in their ability to tell your story, to get you more money.
And they want to work for you.
That's right.
More work when we walk away, but we want to do it because we know there's more there.
Yeah, that's right. Whereas if the lawyer says we have to take it, it's their best offer of the day, that maybe is a lawyer that just has less confidence in your case. Yeah, good point. Good point. So don't feel defeated if your lawyer is telling you, let's walk away. In fact, that should embolden you. That should give you more confidence that your case has merit and it's worth more.
Exactly.
Yeah. I like that perspective. I'm going to use that. Really good way of looking at it. How do you prepare your client for a mediation?
Well, I like to level set their expectations. I first say, this is an opportunity for both parties to come to the table. And I tell them the role of the mediator. And they may be hearing hard stuff, such as the mediator saying, there's an issue here in your file and here. But I let them know it's actually a benefit for us, so don't get discouraged. I tell them that it's very possible that the other side may come up with nothing or a very insulting offer. And I like to tell them, it's because it's a possibility, I want to level set you. However, we're not going to take it. As your lawyer, I'm here for a reason, and my job is to advocate for you. And if I feel like an offer is disrespectful, we're going to walk away. Again, that's an opportunity for us to build the file. I also tell them, of course, we'll take their instructions. However, we will refer to them in terms of our offers. We'll give you an idea of how much we believe the offer should be, the first, second, third, however long it goes. But we will also get their insight. It's a great process of cooperating and understanding where your client really is and their motivations, and us to also discuss with them what we think is viable and what we don't think is viable. So it's very important to give them hope of, yes, it may settle. They may come to the table with a really great offer, and it will be a perfect opportunity to end this, and you can just move on with your life and heal. But also it's a possibility where they may try to wear you down. And I think most of the time, insurance companies will try to wear you down, and I make that clear. So when they hear something they didn't want to hear, they're not set off by it.
Yes. Another important point on that is we always want to tell our clients, you don't have to dress like you're going to a wedding or, anything like that, but have respect for the process. So dress respectfully. I don't want them overdressed, but I want them looking like they're going for a job interview or something like that. I generally encourage clients to bring someone with them, someone they trust, a family member, a spouse, a close friend, because I think that's important during the mediation to also have somebody there in case they want to talk to someone or get some air.
That's a good point. It could be an emotionally taxing process. We try our best, of course, and generally the defense lawyer is kind and patient, but you really don't know until you get to the mediation. A lawyer who was acting very collegial with you on the phone could act completely different in front of their client, which is the adjuster. Another thing is, yes, be aware of your surroundings. A lot of the times the clients will be on Zoom and they'll be in public walking around. There's going to be people around, and it's very distracting, but also in the back of your mind, it does discredit you. We make sure that we say, be in a quiet room, make sure there is nobody actively walking around or talking to you, and dress appropriately. You want to put your best foot forward and you want to show the insurance company that you're human. The whole idea is humanizing you. And if you could help us with that, that is the only thing we really ask.
That's right. And poker face.
Yes.
I always tell clients, when we're alone, you can be open and share your thoughts, but don't reveal too much to the mediator, certainly not to the other side. They're always assessing you. They're looking at how you react to difficult information. If you get your back up and you look angry, then they start to think you may not present well as a witness at trial. And then that's leverage. They offer less money.
From the insurance perspective, we write memos after the fact. And a large portion of what I would write is exactly that, how I believe that client would be as a witness. Were they aggressive with us? Were they angry and yelling and couldn't take instructions from their own lawyer? For us, that's all good. If I see that you are going to be very triggered at even the smallest things, you're not going to be very likable in front of a jury. And I'm going to take that into consideration when and if I make the next offer outside of a mediation, or I just want to push it all the way through to a hearing because I'm thinking this person is not going to do very well. And that's a really good opportunity for me to lowball you.
Yeah. When you were a defense lawyer.
When I was a defense lawyer.
Now you're a plaintiff's lawyer, but you use that to educate the clients to make sure they don't make those mistakes.
No, absolutely. I think my practice area of being in insurance prior has really helped me. It's honestly very different being on the plaintiff side, but all the little tricks and things that we used to do in insurance defense, I now can look out for. So when a lawyer is speaking with me and they use certain terminology and certain tactics that I'm used to, for me, a red flag goes off my head and I'm either able to shut it down or use it against them, which has been, really invaluable.
What about choosing a mediator? Anything that you look for in a good mediator?
For me, a good mediator is someone who's practiced law for a really long time. That's, for me, indicative of the fact that they know the law, they know what to look out for, what the strengths are. You tend to use the same mediator over and over again because you build trust with them. So it's a really good sign if your lawyer knows a mediator because it streamlines the process really quickly and they're very earnest and honest with you. Whereas if you're a new lawyer and you don't know the mediator, there's a lot of little, professionalism that goes into it. But I think the beauty of having a mediator that you know is just they give it to you straight. There's no dilly-dallying. It makes the process really quick and really simple. And you're able to understand the other side a lot better because they're not trying to hide the other side's, position with niceties. And things can get very confusing with niceties. However, I generally like the insurance companies to choose their mediators just because I'm very confident when I go to mediation, I prepare like it's a hearing. So I know my stuff. I'm not concerned the mediator is going to be, leaning more towards the insurance provider because I already know they are. That has already been in my calculation. So if for whatever reason they choose that mediator and they feel more comfortable and more open with us, I see that as an upper hand as opposed to, giving up something.
Yeah, it's funny you say that. I agree with that 100%.
Yeah.
I'm the same way.
Too, yeah.
I don't really fight too much about the mediator. If the insurance company has someone in mind that's going to make them feel good, then we'll use that person because at the end of the day, it's not going to really change my strategy and my view of the case.
Yeah, the facts are the facts.
Yeah.
The work is the work. The brief is the brief. A mediator is really not going to change that.
But with that said, there are mediators I prefer,
of course,
over others. I just think they're more effective. And I will try to suggest them when given the opportunity. But if the insurance company really digs in and has a mediator in mind, it's rarely ever a contentious issue for me. I'll let them choose.
For sure. Of course, I will have my input.
Yeah.
But if they're really set on one mediator or two, I'm not going to say no. And it's not the fight. I think at that level of negotiations, you have to pick your battles. That's not a battle I need to pick because it also may weaken your position or their view on your position. Yeah. They may question why do they need this specific mediator? Maybe, their referral is weaker than they think or etc. So it's just not a battle that's worth fighting.
Yeah, I agree. So a common question we get near the end of a mediation when we're suggesting let's walk away and there's an offer on the table from the insurance company or the defendant, our clients will say, okay, well, if I follow your advice and I walk away, what if I change my mind next week or next month? Can I still get the money that they're offering? Unless there's an agreement to keep the offer open, which I don't like to do personally, and I'll explain why. But unless there's an agreement to keep the offer open, technically, if it doesn't settle at mediation, all offers exchanged are off the table. Practically speaking, it's been my experience that if they've offered a certain sum of money at a mediation, if you called them back later within a reasonable amount of time, unless some major new evidence emerged in the case that changes the case, practically speaking, you can still get that offer. That's been my experience.
I agree with you. I mean, ultimately, there's no guarantee that the offer will still exist, but obviously that's how they value the file and probably less than they value the file. So it'll still be a good business decision for them to take it. But also keep in mind, your lawyer walked away because we believe there's more on the table.
That's right.
Right?
That's the most important thing.
Yeah, there's a reason we walked away and didn't take that settlement value. And they also know that, of course, there's no guarantee, but it still puts us in a better position. And again, depending on what happened between the mediation to when we go back and ask them if that offer still exists, we may have gotten better information, better medicals, and, it strengthened your case. And maybe we can even ask for a little bit more.
Well, that's the whole reason, right? If we walked away, it's because we didn't believe it was enough money.
Exactly.
And we believe it's worth more. And so then our mission, our goal becomes to continue to educate the insurance company and their lawyer as to why our offer makes sense and why they should pay it.
And the beauty is you really can negotiate up until the hearing. So there's no...
Even during trial.
There's no fear in the fact that you're giving up your rights to settle. You're really not. I think it is just one specific tool that you could use to settle, but there are a plethora of ways that we can really get the file settled for you if that's what you want. Something as simple as getting on the phone with opposing counsel and saying, listen, let's just settle this file, etc. It can be as informal as that, or something like a formal settlement offer. Your lawyers will work with you. We will work with you alongside, and we'll get your instructions. We'll ask you questions. Whatever you like, we will do with our advice on what we believe is correct, but we'll always follow suit in terms of what our clients need.
That's right. At the end of the day, it is the client's file, the client's case.
Thank you so much for tuning in today. I hope we gave you a good insight into what mediation is. And what I want you to take away is that mediation is not something scary. It's quite exciting. It's basically signaling to you that your file is well on its way and it's an opportunity, even if it doesn't settle, to look into the minds of the insurance defense company, and an opportunity then for you and your lawyer to build your file up, to bridge the gap, to fill in the holes, to make sure that you get the best settlement that you deserve and the full value of what your file is worth.
If you've got any questions, reach out to us. Our contact details are located in the show notes below.
If this video was helpful for you, please like and subscribe, as we'll be doing a lot more content on a variety of topics.